Hello, hello, hello. This is Attorney Mark Gravel coming to you from Chicago. As usual, as you can tell by the title, we're desperately seeking the Karen accountant. I wanted to see the TPO, but I don't have a link. I was sent a link in Discord, which I think is probably correct. I'm not told that it would necessarily stream. I don't think we're getting a link for it. So I've got a plan B. I didn't say it was good, but I have a plan B. Let's do it, shall we?
You got a cold? Don't give it to me.
No, I don't have a cold.
Incarcerate.
I just had a drink of my smoothie and I think part of my strawberries got stuck.
File number 21-13188FH.
Okay, this is a follow-up on Blubbering Karen. I just did this a couple days ago. She couldn't stop whining. It's quite a difference today.
Appearances from counsel, please.
Good morning, Your Honor.
And I'm Jeff Harrison. I'm here on behalf of Ms. Crum.
Ms. Crum joins us today via Zoom from the
Thanks to Meg for sending this to me.
Wexford County Jail. Ms. Crum, are you able to see and hear us this morning, ma'am?
Yes, sir.
Thank you. Also here before the court is Mr. Kevin Stapleton, the agent from the Michigan Department of Corrections. And we're here today for an informal hearing after having conducted an arraignment last Friday on a request and warrant for probation violation that included 4 counts. A not guilty plea was entered on behalf of the defendant. Defendant requested counsel. Mr. Harrison, what are we doing today?
We would have this set for a formal hearing, Your Honor.
Okay.
We're not in a position to resolve these allegations.
All right. Mr. Wiggins, I asked this the other day. Mr. Potter was in as the probation officer, and it looks like he's a probation officer listed on the request and warrant. I asked him on Friday if count 4 had any new charges. At the time, he didn't know. It appears to have occurred out of this county. Are either you or Mr. Stapleton aware of any new criminal charges?
Your Honor, I don't even have the allegations, so I'm not aware of any.
Okay. Again, on Friday, Mr. Potter said no. Obviously, the reason why that would be important is because you could make count 4 a non-technical violation. Right now, she has 4 charged as technicals. She has 1 prior technical, which means if she's convicted of all 4 or at least 3, she's not limited. The court is not limited to the sliding scale. That's the reason for asking. All right, so we will go ahead and have the matter set for a contested hearing. That hearing would occur within 14 days from Friday. One moment. Mr. Harrison, do you know, is Ms. Crum on probation or parole to any other county or state?
I don't believe she is to any other county at this juncture.
Okay.
It's been a while since I've had opportunity to interact with her.
No problem. Ms. Crum, are you on probation or parole to any other county or state at this time?
No, sir.
All right. Okay. Anything further on behalf of the people, Mr. Wiggins?
No, Your Honor, thank you.
Anything further on behalf of the defendant, Mr. Harrison?
Nothing at this time, Your Honor.
All right. The bond will be continued to be revoked as previously set on the record on Friday, October 20th. And we should be back here within the 2 weeks. Thank you. We are adjourned.
Thank you, Judge.
Is that anything in the county police report?
I'm sorry, Ms. Crum, was there something you needed to say?
No, sir. I was just saying thank you for your time.
All right. All right. Thank you, ma'am. We are adjourned.
Wow, that's a stark difference. It's not exciting, but that's the update.
All right, our first matter is People versus William Randall Elkins. Mr. Elkins is here with his lawyer, Mr. Ross Truckee. He was charged with
If anybody comes across the Karen accountant, feed somewhere, let me know in the chat.
possession of methamphetamine under a felony file number 231837 FY. Prosecuting Attorney's Office, I think through Mr. Robert, reduced this to a use of methamphetamine at the time of the pre-exam conference. I set the matter for sentencing this morning. Mr. Elkins has a lot of baggage on his criminal record and extensive unpaid fines and costs. Mr. Truckee indicated that he would be requesting a 7411 probation. We don't have the prosecutor here this morning, but Mr. Truckee, what would you like us to know?
Well, Mr. Elkins is aware that he has some outstanding fines and costs and understands that at least partially played into the court's decision to hold impending sentencing. He appears to me to be clear-headed and ready to put this behind him. I think he recognizes that methamphetamine has maybe been a problem, that this is the time he got arrested for, if that makes sense. And he indicated a desire to attend a rehab facility in Berrien County should he get out. I want to point out that there was 0.59 grams of methamphetamine that was found. This wasn't trafficking amounts. It was use amounts. Mr. Elkins consented to a search of his person at the time of arrest. The vehicle was searched as part of an inventory because he was arrested on a failure to appear warrant. But he did not, it wasn't difficult with the officer upon the time of the traffic stop. And I think that he's clear-headed now. He's ready to.
I had to do a double take when I looked at him because you looked like you used to look. I mean, you look good.
Thank you.
And I looked and I had to look again. You look about 5 years younger than the last time I talked to you, but you do look clear-headed. And that's part of the reason why I left you in jail for a while, so we could talk some sense here, but you look good. And so that's
Okay, that's 2 in a row. The last appearance and this appearance. Everyone says jail doesn't help anything, and I know it's not always the answer, but a little forced sobriety helped these 2 particular defendants out tremendously.
encouraging. Good morning. I looked at your criminal record. You've got a lot of baggage on here, MDOPs and larcenies and other sorts of things, but you don't have a drug charge. So theoretically, you could be eligible for 7411 probation. Most of the stuff that you got was like you were a bull in a china shop, which had a lot to do with methamphetamine use. And you've been running on 3 flat tires for a couple of years now. And I don't think you want to keep going down that path. Tell me what you did to explore going into treatment.
Well, I've been attending recovery, and a lot of what I thought about was going to AA too, and the stories them guys told.
So you're doing Celebrate at the jail?
Yeah.
Very good.
And AA on Thursdays. And that's what I was reading a book that one of the guys there wrote, and it opened up my eyes, and I don't want to go down the road that they did or end up like in the situation that they put themselves in. I don't want to be like that.
This is like talking to you 10 years ago. One of the deciders was going to be whether you did any services while you were in the jail or you just sat in your cell.
And sorry to interrupt.
Go ahead.
But I started going to class to get my GED.
All right.
And she said that if I was released, that there's a school in Three Rivers that I could attend to finish, because I took all the testing, and I can get out and go to that school in Three Rivers.
Yes. All right. I'm going to give it a shot. your mother would like to see you right now. Being in this shape, she's going to feel like she got her son back. But this is very powerfully addictive stuff, and I'm concerned about relapse. You don't OD on a methamphetamine relapse like you do with opioids or fentanyl, but it sets you right down the path. But I'm willing to give it a shot, Randy, if you're willing to do some of this. You got a whole bunch of unpaid fines and costs, which we'll figure out what we're going to do. I'm going to order 90 days in jail, credit 31, which leaves 59 days to do. I believe that adds up to 90. So you're going to get out today.
Okay.
The fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee.
What?
It's deferred.
Oh,
It's just no-
Yeah, you're getting out of jail. I got 59 days hanging over your head.
You screw up.
Okay. Well, don't not happen.
There's a $940 probation oversight fee. Let's add that up. Which can be reduced. It's $960. $1,235. In 1 year. That could be reduced by $480. To pay all outstanding fines and costs. Substance abuse counseling and treatment as directed. No drugs and no alcohol may go into residential treatment. Test as directed. I'm going to see if they will see you before you're released. If they won't, I want you to, as soon as you get out of jail, come back here. Somebody gonna come pick you up?
Yeah.
Well, just when you get out of jail, you come back after lunch up here to the courthouse.
So I'll just walk, when I get out, I'll just walk straight here. And I could use a phone here to call.
Yeah.
Okay.
Now, if you need a bus pass or something when you get here, let me know and I'll get you home.
Okay.
But if you get out of jail, you'll get lunch, then come over here and meet with the probation department. Have you talked to Lisa or anybody at the jail?
I wrote a kite to talk to her, but she sees so many people that I haven't had a chance to.
All right, well, let's see what we can do. I'm not sure if 31 days is enough, but you've impressed me by doing Celebrate, going to NA, and doing the stuff you need to be doing. You weren't really doing anything except what you were doing is driving around the drug hood, and they're following you around. They said this is a high drug trafficking area, and driving weird, but you weren't really doing anything criminal other than you had about 6 grams of meth on you. And you deserve better. You deserve like a real job, money, health insurance, car insurance. All right. All right, you come back to here when you get out of jail, and we'll try this 74. If you hold up your end of the deal, even though you got all this other baggage, this charge could actually be taken off your record. There'd be no record of conviction. But my goal is to try to just get you like this, so you quit smashing China in the China shop.
Thank you. I really appreciate it.
All right. I am enjoying seeing you like this. Let's see if we can keep it going. One thing you got to do is stay away from the people that are providing the resource to feed your addiction. So let's start with that. All right, you come back up here. Our probation officers will see you after lunch.
Take care.
All right,
Stay off the numbered streets. I will.
I wanted Crazy Karen accountant, but we got Mayberry instead.
I'm gonna stay out of town.
You don't have to stay out of,
Well,
just stay out of trouble, all right?
Yeah.
That'll make me happy.
thank you.
Okay.
And me?
This is People versus Devon R. Moore II. He's here with his lawyer, Mr. Ross Truckee.
I can't remember. I just grabbed this as a plan B, but I wasn't paying attention. I think this guy goes on a nutty adventure.
Let me get into this file. This was originally charged as a felony, carrying concealed weapon, 2 counts, operating while intoxicated, carrying a pistol while intoxicated. This has got a lot of bad facts in it. And Daniel has prepared the screening report. He's not here yet.
Oh, this is pretty dumb.
Mr. Truckee, what would you like me to know?
This is hardcore dumb.
Well, I think the recommendation of the agent is fair and appropriate. They're primarily recommending services designed to transition Mr. Moore from youthful stupidity into adult wisdom. This is, Your Honor's
I'm
correct.
gonna write that down.
There are
We
some,
need more of that.
there are some bad facts. And I think this was maybe things kind of piling on one after another. He was going through surprisingly at his age, a divorce also. So things just kind of snowballed and we have a whole bunch of bad facts. But I think Mr. Frazine's recommendations are appropriate. I think that Mr. Moore will show the probation department that he's committed to doing what he needs to do. I may hear Miss Davis.
Yes. Or Rhonda.
So I would just ask Your Honor to adopt the probation agent's recommendations as written.
We try to have consistency. We have some sentencing guidelines, but the recommendation for Mr. Moore compared to the recommendation for Mr. Galvez, I don't know, it's hard to compare apples to apples. Here's Daniel now. Daniel, why don't you come up and have a seat? We're on Mr. Devon Moore.
Yes, it's my client's knucklehead defense, and it's the best one available. And his attorney does a good job with it, honestly.
This case is eerily similar to the arrest of our sheriff. That was in Kalamazoo County. You hit another car. You sideswiped a lady who was driving down M66. You left the scene of the accident. You crashed your car then here in Centerville. You were intoxicated. You refused the breath test, at least the preliminary breath test. You had a loaded gun in the car under the seat. You had a knife under the car in the side pocket. You had a lot of marijuana in the car. So in addition to drinking,
Let's see what we got here. We got drunk, drugs, multiple collisions. All right.
you'd also smoked marijuana. You had about a pound of pot. I'm not sure how much it was. Quite a bit. And I don't know what the heck you were thinking.
The only thing this spree's missing is a hooker. I gotta be honest, I'm a little disappointed.
So the recommendation is 2 days jail credit, 2 days. I guess I have some reservations about that. Mr. Moore, what do you want to tell me?
Your Honor, the first crash I had was a deer. And then the second crash, I did hesitate to stop.
Those damn deer. A guy's just rolling around with a loaded pistol, a pound of pot, drunk, and that deer goes and messes everything up.
When my tires are bald, but I looked back and the other car did not stop either. The marijuana,
that's Judge Middleton's "I don't believe you" face.
is no excuse, but it's shape. It's more of a trimmings.
Oh, there are a lot of deer accidents in the state of Michigan, for sure. For sure. That's a real thing, but that's not what happened here.
Well, I don't know about a deer. Someone called and said there was a hit and run accident at M66 near Findlay Road. The vehicle was described as a silver passenger car with driver's side damage. Let me go back to the earlier report. I made contact with the caller. Driver advised she'd been westbound on M66. M66 runs north and south. Southbound on M66. So she was headed toward Minden. Suspect vehicle, swerved off the roadway onto her left side of the road. She hit her brakes and swerved to the right. And the vehicle swerved back onto the roadway. The vehicle sideswiped her vehicle and continued northbound. So she stayed there and called the police. Then they're on that scene, and there you are in Centerville. And they found where you'd gone off the road for 50 yards before re-entering the roadway and hitting that lady. They also found multiple parts of your car on the roadway, so maybe there was a deer, I don't know. But you left. Then you go to Centerville, and they find you and you give them some bogus story about being at your brother's house. So you hit another car on M66 and left. And that's, at least to me, that's important. And you got
Yeah, it's a relevant fact, Judge. I'm going to have to go ahead and agree with you.
this gun in the car, which has been a recent unpleasant trend. We've got probably in the last, since summer, I've had a dozen or more young people with guns in the car. A few of them had a CPL, you didn't. So the gun wasn't stolen or anything as far as I can tell, but you didn't have a permit to carry a gun. And you got a loaded 9mm under the seat in your car while you're driving around drunk. And for some reason I don't understand, you have a big knife in there. You refused the breath test, you lied to the police, and none of that's good. Daniel, you put some thought into this to make the recommendation you made. What else do you want me to know?
When I spoke to Mr. Moore, he had a lot of, he tried to make some excuses, but then he came around.
Well, which is what he just did.
Yeah.
He didn't say, hey, I'm sorry. He's like, I hit a deer first and this isn't correct. So he hasn't really shown much remorse.
I think he's definitely behind on the maturity level, and he needs to grow up. That's why I put the gun safety in there.
I don't want gun safety. I don't want him having a gun.
I don't really want him having a gun either, but he has no training with any guns. And I know in the past, when I'm looking at the last, because I think I have 4 of these on my caseload that are somewhat similar to this, and they've all had the gun safety. And I thought that was a good thing because I think most people could benefit from a gun safety class.
I'm not doing gun safety. I don't even want him to use or possess a gun. If he's driving around with this isn't for hunting. This is a loaded pistol. But anyway, go ahead.
And just
I'm going to have to agree. Gun safety isn't the issue here.
regular drunk driving stuff like VIP, substance abuse assessment, fine for life. He's going to do some regular testing. He'll put him on the color chart right from the get-go. And $255 police reimbursement requested from St. Joseph County Sheriff.
All right. Mr. Moore, anything else you wish to say?
I am very sorry for what I have done. The pistol was not mine. I dropped off friends and did not check my car before leaving the scene.
He's a victim.
It's under the driver's seat.
Yes, I'm assuming the person who was behind me dropped it in or threw it under my seat. I have never had any thing with a gun before.
Of note, Your Honor, Mr. Moore did bring with him a document from Pivotal involving his recent engagement and services with Wendy Ludwig. So note that he has taken that step outside of the courts.
Well, that's good to know.
Nice redirect.
What about the knife?
The knife, sir, I've had that since I worked at a trailer factory. I found it in a parking lot and I liked it, and so I kept it ever since. They had a cover on it, a case.
Okay, I'm assuming that's a yes. Okay.
On the firearm charge, I'm going to order 2 days, credit 2 days, concurrent with the OUIL charge. We don't have a benefit of any prosecutor input here, so I'm not sure what their thought was. On the operating while intoxicated, I don't know if there's an issue of restitution for the car that he hit. I am going to do a 24-month probation, 7 days jail credit 2, leaving 5 days to serve, which is at the top of the sentencing guidelines, which will be done on weekends or whenever your weekend is. Are you still at Harbor Freight?
Yes, sir.
There's a $300 fine, and all this money is money you could be using to support your child. But this carries financial consequences as well. $75 crime victims' rights fee, a $50 state minimum fee, a $100 screening fee, $150 attorney fee, $960 probation oversight fee. I expect you'll be discharged at the end of 12 months. which would save you $480. Police reimbursement of $255 to the St. Joe County Sheriff's Department. Reserve on restitution. Daniel, did you get anything regarding restitution?
No, they said they had nothing last time I spoke to the prosecutor's
All
office.
right,
but
well,
this
they're
last
not
I
here
heard-
to tell us, so, firearm and knife forfeited. Firearm ammo
Just because
are forfeited.
Michigan,
You're not to use or
them
possess
on
a
YouTube.
firearm during this probation. 1890, that's a lot. Payment is due in 1 year. All right, we're gonna do alcohol testing as directed, no drugs, no alcohol, abstain from alcohol and controlled substances, including marijuana. You're 24, you're old enough to use marijuana for recreational purposes. But while you're in this probation, we're doing a timeout from everything. I assume you'll be positive today.
and
We'll get
Texas,
your levels and get them to 0.
and Kansas.
It's also money you won't be spending on recreation that can go to child support or find some costs. I go into Harbor Freight sometimes. I'll say hello.
Oh, I love it. I love it. I go into Harbor Freight sometimes. I just say hello. Okay, Judge.
But I want to see you hold up your end of the deal on this probation. All right, you can go down and Daniel will meet with you on this.
He really is. All right. Well, then this is what we got.
You to make sure that everything is fine with you. So we're going to bring you back on December 12th, but if everything is, I'm sorry, yes.
Had an evaluation.
Oh, you've had a competency evaluation? When did you have that?
About 2.5 weeks ago when I was upstairs on 5th floor.
Okay.
I'll look into that.
All right, Norma, let's do this. Give me a date for him in November, the second week in November.
I get a PR bond or something and I already had an evaluation.
Hold on.
November 13th.
All right, so this is what will end up happening. If your attorney wants to file an application for a PR bond, he can file an application for a PR bond. I'm not your attorney. I'm not allowed to do that. So your attorney will have to file it. And if your attorney files it today, we will have it heard tomorrow. Do you understand?
So when are you putting off my court date until when?
November 13th.
There's nothing I can do to go home today. I mean, I already had an evaluation.
Okay. All right, Mr. Wolf, you want to speak to your client and see if he needs another evaluation?
I'll talk to him.
All right, thank you.
Will I be able to talk to him? I know
Sure.
you have court going on.
Jeremy Garcia? All right, thank you.
Another purse I've never seen.
And probation, this is an application for deferred. Hello, good morning. I'm gonna need you to make sure that you speak up because we have a lot of things going on here. Mr. Wolf? You're gonna have to be moved down to the end. So if you'll wait to talk to your client once we're off the record, or if one of the attorneys finish speaking to their client, okay? All right, court is calling 2023 CR 7562, State of Texas versus Jeremy Ray Garcia. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
John Coons for Mr. Garcia.
And are you Mr. Garcia?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And
Yes.
did you sign it?
Yes, ma'am, I did.
Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am, we are, Judge.
We're on the record. All right. We are on the record. Counsel, I'm sorry, Mr. Garcia, showing you what's entitled court admonishments and defendants waivers and admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
All right. Did you understand you're charged with theft of a firearm? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application of deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes and yes.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am. I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, state recommends deferred adjudication. They're taking in consideration 712934, 716, 716. Did you understand that to be the plea?
Yes, ma'am, I did.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I have.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and no harmful or injurious contact with Alicia Gonzalez. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I do.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Your Honor, I offer State's Exhibit 1 and the attachments. We reviewed them and have no objections, Your Honor.
All right. And with regards to the no harmful or injurious contact with Alicia Gonzalez, she's aware of what's happening and that is what she's requesting?
Well, ma'am, another prosecutor's spoken to her, and based on the notes in JD, it seems to be what she is requesting. Judge.
All right. Thank you. You may be excused to continue to confer.
Thank you, Judge.
Mr. Garcia, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am, I have.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses, statements, and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
We'll catch up to regular speed here in a minute.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, please.
Anything you wish to say on behalf of your client?
Judge, obviously, we're requesting you follow this plea bargain. He made a terrible mistake a couple of years ago when he needed some money. He was in a downtime in his life. He has several small children, and he's very apologetic and is very grateful for this opportunity. I've explained to him how important it is to successfully do everything on probation, and that if he does well, that there's a potential that his probation could be terminated early. He understands that. He is looking forward to getting back with his family. He has been in custody this current time for about 2 months already. So he's looking forward to getting back and going back to work and trying to help support them.
All right. Is there anything you want to say?
Just that I'm grateful for this opportunity. I just really miss my kids. So
Well, you know, it's your fault.
yes, ma'am.
All right, this is what the court is going to do. 4 years deferred adjudication, no harmful or injurious contact with Alicia Gonzalez. Take in consideration County Court Cause number 712934, 716716. Are you currently employed?
Yes, ma'am.
Doing what?
We put in office supplies for call centers.
Okay. So nothing like before.
You're not going to gun shops or anything like that, are you?
Oh no, I was installing security cameras at the time.
So I'm assuming nobody's using you to install security cameras anymore.
No, ma'am.
Okay.
Unfortunately.
Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. Regular reporting by Zoom or in person. Regular UAs. Field visits. 1 time per month for 3 months. Probation, if there are no issues, then you can discontinue field visits or as you deem them to be. There should be 80 hours of community service restitution. I'm going to order parenting classes. Once you completed the parenting classes, then your community service hours will be deemed satisfied. Probation, is there anything else he needs?
No, Your Honor.
Is there anything else you need from me?
No, ma'am.
Nobody requested a theft course, so I'm going to give you your theft course. Don't take what doesn't belong to you. If you're taking something, you need to pay for it. Do you understand?
Yes, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am. I do.
All right, we can go off the record from here on out. You need to be trying to make your children proud of you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're
Thank you,
welcome.
Judge. Thank you.
Thank you. Jose Ruiz, why do I keep getting this file back?
Oh, Lorraine actually had to run to the 186. I'll text her and let her know.
Okay. All right, we're done with that. Kevin Corral.
Present.
All right. So today is discovery day on this case. Where are we on discovery?
I think we've received it, Your Honor.
Okay. And has an offer been tendered or no?
Just as we speak, earlier just this morning.
Okay.
And so we haven't had a chance to confer with my client regarding the offer.
All right, Ms. Ferguson, can you recall this for 30 days for a plea deadline date? All right, we'll come back on November 30th. At that time, you need to let the court know whether or not you're accepting the state's offer. Do you understand? All right, thank you. Once you sign the reset form, you're excused.
Come on, somebody come try to BS Judge Boyd.
Paris.
Help my stream out.
They still have your client downstairs.
We're still waiting on a competency on this one, Judge.
Oh, you are?
I haven't received a report yet to see that they've completed their evaluation.
All right, let's do this. Let's make sure we get him out here so he can know what's going on, and then we'll get a date and everything.
Yes, ma'am.
Carlos De Leo. All right. Where are we?
Trying to pick a side here.
Okay.
Morning.
Good morning. Well, y'all have the brains of the operation behind you.
I know.
That's what I'm saying.
I'm over here on the side.
Okay. All right. So where are we on this?
The last hearing we had, we got some results back from Houston Forensic Science Center, and we were requesting the underlying data to support those findings and conclusions. We've received that.
Okay.
I am in the process of giving that to my client and to our expert for analysis. Unfortunately, for my purposes, my client is not able to look at anything digitally, and it's a whole bunch of stuff digitally. And so I've got to put that all out, get it over to my client and to our experts. And
He can't listen. He can't look at anything digitally. Okay.
There's no PDFs. Yeah.
Alrighty.
So that's where we are, and we're in the process of trying to get all that done. And I'm hoping that once we get that analysis looked at and done, we can get an expert opinion back on that and be able to proceed and go forward.
All right. How long are you all anticipating this? Because this is one where there is a conviction, and we're just trying to see if that conviction is a proper one.
Right.
So
Matt and I were talking today, and we're thinking at least 90 days, maybe even 120, get us through maybe February before we're going to be able to have an expert review. It's a ton of stuff, Judge.
Okay.
It's just a ton of stuff. And so we've got to figure out
and your client is not in prison.
He is in prison. On this one, he's in prison. The other one, he's not. He's actually out on parole.
All right. So which prison is he located at? So would it be easier to have him bench warranted back here? I know there's an issue with the time. Would that make things run smoother?
No, not really. I mean,
Okay.
because really what we're looking for is our expert analysis on the underlying data and the results that were obtained from.
Well, I mean, I know because you said he needed to review things. I'm wondering if that would make it easier. If not, then it won't.
Knowing my client, he wants it. He wants the actual results.
No, I mean, bring him here
Right.
and he can look at whatever you want him to look at. But if you all don't think that will make things run any quicker, that's fine.
It's not, Judge. I
All right.
appreciate that, though.
Sure. Ms. Ferguson, they're asking for 120 days. Normally that's never done, but okay.
It's just that we're not wasting the court's time coming back. And
It is never a waste.
we're still working on it.
Okay.
And Judge, so the court's aware, the state is prepared to, I mean, the final piece of the puzzle here is that 6404 hearing.
Mhm.
We're prepared to move forward on that, but I mean, the big issue here is that Mr. De La O has to carry his burden. We want to be able to, we want to give him as much time as possible, give Mr. McLean as much time as possible to review documentation here, basically be ready to have that final hearing. So really the last statutory requirement on the court is that 6404
Yes.
hearing.
And no, we'll have it. And I want to make sure that everybody has everything that they need to go forward.
Appreciate that.
All right, we're going to come back on February 22nd, 2024. Time has gone by quickly.
It has. All right, we will do our level best to be ready on that day, Judge.
All right, thank you. You're welcome.
See you then.
This is what court is like for me all
Nicholas
the time.
Ramos.
You all ask to see me. This is what it's like. A bunch of reasonable people saying reasonable things. It's a snooze. Somebody bring a crazy client. We have a contestant.
So how many cases are we proceeding on? Just one. Okay. All right, court is calling 2023 CR 3133B, State of Texas versus Nicholas Ray Ramos. Can I have parties announced for the record for the state?
Daniel S. Clark for the state of Texas.
On that side.
Anthony Cantrell for the defendant.
And are you Nicholas Ray Ramos?
Yes, ma'am.
Counsel, you received all the discovery and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ramos, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged by indictment with aggravated robbery? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Okay. According to the plea, punishment is to be assessed at a cap of 16 years in the prison. There are no applications. This will run concurrent with County Court Cause number 6915486915449
I'm headed to Colorado
694-250. And there will be
with the
several cases
flamingo
taken in consideration. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
for a little
Yes, Your
skiing.
Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
All right, so $100 fine, no restitution. You will be responsible for court costs of $158 and supervision fees of $60. And then you haven't worked, it sounds like, for 90 days or so.
Yes.
I will waive your attorney fees. I'll give you a 6-month non-reporting probation to be supervised by court services. And you will set up the payment plan with them. But I want you to pay. What kind of work do you do when you're not in custody?
I've done window washing and I was working at Dillon's for a couple weeks, also around February.
All right, I will
Daughter.
let you
I call my
set up
daughters
your payment
flamingos.
arrangements with them, but I want you to try to make monthly payments at least starting in November, some type, so that you don't just let this snowball and not get it done. But most importantly, I want you to do a domestic violence offender assessment. That's a certified domestic violence offender assessment done by a certified domestic violence offender assessor. And I want you to have the appointment for that within 7 days. Call and get the appointment. You can't have the assessment done, I'm sure, in 7 days, but you can at least get the appointment made and get that started as soon as possible. And you will have to pay for that. You will have to do whatever they recommend for you. Might be a anger management program. It might be something more intense. It might be something much less intense. But that is going to be a condition of your probation, as will all standard conditions. And as soon as you are released from the jail, you will need to contact your probation. Go directly to probation or call them and see what they want you to do next. And the jail has their number, or I can give it to you if you can write it down. It is 316-322-4153.
All right.
Did you get credit for time served against your sentence as well? Anything else, Mr. Patterson, for the defense?
No, Your Honor.
Anything further, Mr. Canfield, for the state?
No, Your Honor.
Very well, we are in recess, and Mr. Horton, you are excused and released at this time. We'll be in recess. Thank you. Mr. Patterson, did you want a breakout room to talk to the folks at the Sallyport? I think you have a
Yes.
couple.
Yes, Judge, I'd see if I can have a breakout room with court security 2.
Court security 2, yes. Savannah, if you could arrange that, please. And Deputy Coffelt, who do you have with you?
There he is. Jay Regier, everybody. In the house.
I have James Perkins, Your Honor.
I don't see the stash today.
At this time, we will be on the record
Stone Cold is here.
in case number 2023 PR 2511, State of Kansas versus James Colton Perkins. Appearing for the state, please.
Jared Regier on behalf of the state, Your Honor.
And Mr. Perkins, do you have counsel today?
No, Your Honor.
All right, so Mr. Perkins is appearing pro se and in person. Mr. Perkins, you are charged with alternate counts of driving under the influence of alcohol or drugs and a defective muffler charge, as well as failing to maintain a single lane. These date back to June 30th, 2023. How is it that you do not have an attorney? Are you going to represent yourself?
No, I have an attorney. He just couldn't come. I had to get my case number. And and he wanted me to get my case number and bring it all to him. Then he wanted me to come back and bring him all the information. This is my second hearing.
Who is he?
John Beats,
John Beats, and how do you spell that last name?
Viets.
V as in Victor,
Yes, ma'am.
I,
Or Veits.
Veits.
Yes, Your Honor.
Is this an attorney from Wichita?
No, he's from Independence, Kansas.
Independence, Kansas, okay. And so as soon as he gets some information, probably some payment, he's ready to enter on your case, is that correct?
Yes, Your Honor.
All right, well, so you're needing another continuance to shore that up. How much time does he need to do that?
A couple weeks, I'd say.
All right, Mr. Regier, your response to this request for continuance?
Well, Your Honor, certainly counsel is something that the defendant is entitled to constitutionally in these types of situations. Nevertheless, based off my notes from the last hearing, it would appear that we are in a somewhat similar situation where the defendant had made allegations about him already having an attorney. So I suppose the court does want to set this over one time. I'll certainly be looking at this a lot more closely.
No objection.
Certainly the state does have some concerns about the lack of headway made on this case so far, given that the
Give him the hook.
information does specifically indicate that the alleged incident is said to have occurred almost 4 months ago at the end of June of this year.
Well, in Marbury versus Madison.
Yes, and with the court's crowded docket, it's going to probably be a while before we can put it back on. Savannah, is there any chance you have a short opening to make sure that he gives counsel rather than setting it over to January? Is that possible?
I mean, we're pretty booked, probably have about 35 to 40 cases on every docket.
All right, what's the next one you have available then?
Next available is January 29th.
Kansas Day. All right, Mr. Perkins, I'm not happy about setting this that far away, but it certainly gives you and your counsel time to get everything you need to do taken care of. So make sure your counsel is ready to go and
Yes, Your Honor.
either announce a disposition or a trial January 29th at 9 a.m.
Okay.
That should give him time to get all of his discovery, talk to the prosecutor, decide if the two of you want a trial or how you want to proceed, because by January 29th, this case is going to have quite a bit of age to it.
Yes, Your Honor.
All right, thank you, sir. You have any questions or anything I need to take care of before I let you go?
I think that's it. But I
Okay.
appreciate it.
That's all right. Mr. Regier, anything further?
Your Honor, my notes from the first appearance here before Judge Crum suggest the court had specifically ordered no possession or consumption of illegal drugs or alcohol. I'm assuming those are the continuing orders of the court.
Are you aware of that, Mr. Perkins?
Yes, Your Honor.
All right, you better abide by that order or you'll lose your bond and be locked up until January 29th.
Yes, Your Honor.
All right, thank you, sir. You're excused at this time.
All right, thank you.
You're welcome.
My next one is going to be Clark Weitzman.
With an L?
Last name Weitzman with a W.
Oh, okay.
W-I-E.
Yes, he's last on the list, Weichman.
Yes.
We are on the records in 2023 TR 2205, State of Kansas versus Clark Lewis Weichman Jr. Please announce appearances.
Every year on behalf of the state, Your Honor.
And Mr. Weichman appears in person and pro se. Well, now I show Darren Patterson as his attorney deputy.
Durham Patterson, your attorney.
I haven't met with anybody yet.
He says he didn't think he had an attorney.
All right.
I am showing an order appointing counsel with respect to Mr. Patterson. In this file, perhaps it would be prudent to take a recess.
Now I'm showing that we appointed Darren Patterson.
Recess time.
June 29 of 23. So Judge Ricky approved that and ordered that. So I am going to take a recess, and after he talks to his attorney, we will take this case again. I expect folks, when you have an attorney appointed, you need to call that attorney and set up a time to talk to them. All right, let's trade him with someone else. And in the meantime, Sean Lutz, who do you have?
Well, I was supposed to
Okay,
be.
just sit down on the bench.
Sean Lutz, if you'd unmute, please.
Yes, Your Honor. Hi, I have Francisco Vasquez Cervantes. It's 23 FP 25.
You don't have it.
We are on the record in 2023 FG 25, State of Kansas versus Francisco Javier Vasquez Cervantes. Please announce appearances.
Here, Ricky, on behalf of the state, Your Honor.
Your Honor, Sean Lutz appears on behalf of Mr. Vasquez Cervantes.
And how does your client wish to proceed?
Your Honor, I had spoke to Mr. Regier last week, and I thought we were going to get a resolution this morning to this case. But Francisco called in this morning and is sick this morning. This is a first time setting. I just asked that it be set over one time, and we will get it resolved next.
You mean it's a first time control setting?
Yes, Your Honor.
You said you talked to which attorney?
Mr. Regier.
Mr. Regier, your response?
Your Honor, my understanding is that counsel and I did have some communications about a possible plea offer as recently as last week. While the state was hoping to reach a resolution, if the court is so inclined to grant the request for the continuance, the state would respectfully request that it be set on the docket as soon as possible.
I wonder if we could set this on the Judge Lee docket if counsel is confident it is for plea.
Handled early. 26 of the. So am I to understand that when phone calls are given over, there is no sequence to them that one could figure out by what's given?
Your Honor, I can say that this is the third case that I have received phone calls like this.
And I can say that's not my general course of practice. When I've done these types of motions, I provide the relevant phone calls and I try to rename them with the corresponding dates and times. So it's definitely something that I can address. But I understand, given the volume, perhaps why that.
No, I get why it may happen. Okay, I mean, I can grasp that. What I have a problem with in this case is, well, in this, and there may be others that I have the same problem, is I've got counsel I've got people who have filed a motion for forfeiture by wrongdoing. That has to be established in some way. Ms. Gaines is disputing probably not the words of any particular conversation, but what I'm to do with that. But the only way that I can do anything with that, or that Ms. Gaines can make her absolute argument, is if she's able to place those in order so that whatever's being said in this conversation has its context to the best she can figure it out, or at least be able to argue. Am I close?
I don't even know what that is or why I need it.
If I may add, although more than one attorney from their office has provided me calls this way, none of them have been Mr. Emmons. But I did,
I'm sorry.
none of those persons who did it were Mr. Emmons, and I had
Okay, so,
assumed
but
that was the practice, given there were more than one person who had done this, but neither, none of them were Mr. Emmons.
No, someone just told me it got spicy over here. And Boyd's call
this isn't gonna make,
and Webster's call was too mellow.
I mean, I'm not sure. I mean, given their motion, I don't know that I'm in a position to deny their motion. But I'm also not in a position to grant their motion. I mean, I'm kind of caught in this netherworld because I don't know total, how many calls are we talking?
I'd say, I think it's about 100. I mean, for a determined period of time, from when he was arrested on August 5th to, I think, September, when the motion was filed.
And I think that's probably correct. I would add that I received a triplicate, and therefore it was what I have is not merely 100 links. I have more like 300 links.
I think that had to do with the links expiring though.
No, I get it. I get it. But regardless of what link you're opening, you don't know what date and time we're talking about in the call. So out of curiosity, because I'm not on that side of it. So you get those 100 those 100 things, and then what? How do you,
So then,
if there's 3 calls, then how do you know which 3 out of the 100 to pick?
so I did not until Mr. Emmons provided me.
Okay, all right. This is,
Until Mr. Emmons provided me with that day when we were in court last. So I literally have, and it's not in this number, but I literally have a list of the different names and a quick jot. Because as I said,
can I ask?
And may I also just say that I didn't just receive the calls, I also received the commissary orders. I received the checking of the PIN numbers in terms of how much money is in there. So I'm literally going through each of these saying, oh, okay, so that's about PIN.
I don't know yet.
Okay, that's about commissary.
Okay, I get it. So, Mr. Emmons, this spreadsheet that's generated. Is there a
Finally get our
reason
spreadsheet.
why? And there may be one, I don't know. But is there a reason why defense counsel can't get the spreadsheet?
So I can provide a copy of the spreadsheet. It doesn't print well on because the spreadsheet itself is so long. It doesn't translate to 8x11s very well.
It's Hodge, Judge.
The bigger problem, for what it might be worth, is that it won't show that file number, the file name, that 10.26.1, blah, blah, blah. It won't show that on the spreadsheet. That's not, it'll show the download button, and that download button has the link, like if you, in HTML, if you hover above it, you can see the link at the bottom of your browser.
We need the
But
Karen
it
account
wouldn't
bad.
print that out. If that,
It'd straighten this right out for us.
but it'll show.
So
The date
just
and
so that I'm clear, if you were to send the spreadsheet over and Ms. Gaines has 100 links and you send a spreadsheet over with that, she couldn't tell from looking at that spreadsheet, what link occurred what day.
Yeah, not necessarily. I mean, there would be some caveats, some different, right? Like you would know the phone number that was being called, right? So you could tell when he was calling commissary, you could tell when he was, you know,
Yeah,
you'd be able to match those things up. But when he called a particular number.
Yeah, but hold on, she would. Oh, so really, this is making less sense to me the more I think about it. Because if you sent the spreadsheet over and she has and so there's 100 things on the spreadsheet. She gets 100 links. She can't connect up those links to that spreadsheet.
Right. Yep.
Okay. I don't use this very often, but that's a stupid system. So if Ms. Gaines wanted to go back and listen to the calls a month before and say a month since, to maybe argue context of these original, of the subject calls, she can't do that. She can't do that without somebody pointing that to her.
Right. Yep.
Okay.
Sure.
All right. So again, I just want to make sure I've got this right. So if the prosecutor points out 3 calls, says here are these 3 calls. Defense counsel can't double check those 3 calls, or as Ms. Gaines is trying to do in this case, give context to those 3 calls. She may not be disputing the calls at all, but she can't give context to them because in this mass of 100 calls, she's got to find those calls because they don't come over in order, right? I mean, they don't come over in some chronological order.
Not that I can ascertain. There's nothing that seems to me that there's any problem.
So just, I see you shaking your head, Ms. Gaines. I just want to be clear. So if you click on the first link, that could be a call from, and then you click on the second link, those calls may be unrelated to, like, they're not chronological. It may not be that next call. It could have been a call way before.
And as it's stated in their motion, that, and I believe that this is common, that people, because they may only have so much money or whatever, use other people's numbers. There are clearly at least 2 that I'm certain are not Mr. Caldwell. But again, and
Are not Mr. Caldwell.
and this is called, I'm certain because it's a Spanish speaking couple and he's not. So that's in there too. And so because they're pulling from
His pen.
or I'm not sure, but whatever it is, because of the sharing, there are things that are completely unrelated to the case. Besides the.
So even if I were right now to try to fashion an order to say, provide the date and time for the calls that occurred within this particular date range.
There's your order. List the calls in chronological order, damn it.
You'd have to go back and do that. Yep. And then get them to. Ms. Gaines, do you know the date range?
It sure does.
I do not know the full date range. I'm assuming it's from.
That is exactly how I deal with this. If I was faced with this conundrum, I would say, Yesenia, can you fix this? I don't want the judge to yell at me, and it would be done.
The time of.
Well,
Is arrest to our September 19th court date? But
And you would need all of those to place contacts, is what you're telling me. How long is it gonna take you to do that?
For all, if I may just, I see the court's point, if I may just elaborate my point of view on it.
Sure.
Our motion makes mention of 3 calls up to August 15th. I think that August 15th, maybe a couple days thereafter, would really be the focus of, was there any wrongdoing from August 5th to August 15th, 17th? I think that's shorter.
I see what you're
We
saying.
get all the context that there would be, because we're not making mention of anything that happened after that. So whatever context might exist should have already been, logically would have already been, the context would be there within those calls.
Your Honor, that's nearly a whole month before the court date. That I think that in itself,
A month before.
for the court date where she was subpoenaed, Mrs. Caldwell was subpoenaed to appear on September 19th. How can we take a couple of phone calls
I see.
when it's more than a month before she's actually?
What's your date range?
So I would want it through the September 19th.
From August 9th through
I believe
August 5th
That's the date of the incident.
through September 19th. And that's the 100 calls. Basically,
I mean, if
give or take.
if I'm able to, reduce it down to her number, I mean, it will be, that means weed out the commissary phone calls, weed out when he's calling inmate information services, that'll take it down a little bit. We're probably talking about, at that point in time, maybe 60, 70.
Okay, so let's say there's 60 to 70. I mean, I think Ms. Gaines makes a good point.
Sure.
Up to the time that basically she would have been subpoenaed to appear. So those 60, how long did that take you to do?
Court gets me to the end of the week, I mean, I can really bust and try to get it done.
And then once that happens, then you, Ms. Gaines, have to listen to them. Right? Formulate. Okay. All right.
Yeah, again, I would argue that, this is information that we should have been provided from the beginning. And that.
Well, I agree with you, except nobody up until today let me know that this was the process, that this was the stop, right?
I apologize. I didn't realize that my argument last time was unclear, because this is what I was arguing.
Well, you were arguing the context of it.
I could not tell the context because of the numerous calls, and that there's some in Spanish and
I'm
there's some in
invested.
commissary. That
Right, but
in the spreadsheet Donnie broke down.
no, I understood the notion of the context of the call. What I didn't understand is you can't place the context because you don't know when these calls. I mean, I had no idea that you get 100 calls. You have no idea what order they're in. They're just coming at you. I think certainly if I had heard that, I would have been addressing that at our last hearing. When was that? Last Tuesday. So here's what I'm going to do. This is because this is the only way I can. Today's what, the 23rd? You need to get those done. And I'm not saying by the end of the week, I'm saying by the 26th, so that they're in Miss Gaines' hands. The 26th is about 3 days from now. By the end of the close of business Thursday, they need to be in Miss Gaines' hands. Miss Gaines is then going to have, and I'm just splitting the time frame in half. That's all I'm doing, folks. There's no magic to this. Then that way Miss Gaines will have the 27th, 28th, 29th, and 30th And at some point, she has to kind of communicate with Mr. Caldwell about what she sees so that, because he's gonna, and I don't know this for sure, but he's also gonna be giving context to what these calls mean with her, but she doesn't even have the order. And then I'll hear the motion and do the exam on the 31st. That's the best that I'm gonna be able to do, folks, because I don't have the information.
Is listening to those three calls. We just went through these yesterday. The phone call.
Sir,
Oh, good Lord.
Sir, you got your law degree where? Where'd you get your law degree? Because you got one of the best attorneys in the county standing there next to you arguing this case, and you want to argue it yourself.
I'm just saying we have.
Well, if you want to argue it yourself, then I'll not pay attention to what Ms. Gaines said, and then what I can do is I can grant their motion, and we can proceed right now. Is that what you want to do?
I mean, that's about the most unfair thing that.
That would be unfair, which is why I'm not doing it.
Why are you threatening me with an unfair?
Because I don't know why you're talking to me.
This is most absurd.
Okay, all right. You're gonna come this close to contempt, so I'm gonna tell you just to be quiet. I'm 30 days, 30 days. He's got 30 days contempt. I told him to be quiet. He can keep talking if he wants. You want to keep talking? You want to keep talking?
You want to answer your question? You're asking me questions.
He's got 30 days contempt. Take him out. I've given you the schedule. That's what we'll do. This is adjourned to the 31st.
Wow. I did not see that coming.
26, close the business. Then you've got your argument, and this is adjourned to the 31st.
Just a moment.
Yeah, I just want to check one thing with these guys because I think there was a child issue on the last day, and I just set this on Halloween, which means you got little ones, which means they've got to go places. That's going to be a difficult day for you guys, right? Is it going to be difficult all day for you, or what?
Handled early. I can.
You sure did.
No, I hear you. I hear you. If I could, all right. So I'm gonna just do this way. And you're gonna hate me for this, but that's okay. I've been hated before. I want, because these guys have been here 2 times while we've been arguing the motion. On the 31st, let's try to get them handled quickly in the morning. Okay. Or better yet, why don't we do it this way? Can they be on call?
I have no objection to that.
All right, because that way, gentlemen, here's what I'll do. I'll hear the motion so you guys don't have to sit through this. And then you just be on call with the prosecutor. And if we need you, then we can get you down. How's that sound? I don't have a.
I don't mean to bemoan the point.
But you're about to.
I'm about to. You've given him the 30. Are we in a rush to have it on the 30?
I'm in a rush to have it unless you guys can agree, because I'm sure Ms. Gaines is going to try to get me to set aside that.
I imagine you would.
So.
Just trying to
Yes.
get as efficient as possible.
All right. His bond will continue. Thank you.
Well, there you have it. There you have it. Random call surfing finally worked out for us. Judge Boyd has some good ones, but everyone was behaving themselves. Judge Webster has good ones, but everyone was behaving themselves. But someone in the chat told me it got dicey in in Judge Simpson's room, and they were right. They were right. We were a little bit behind, but yeah, we were probably 20 minutes behind live there, I think. Good times. I did not see that coming. The guy wouldn't shut his mouth. Why? That was the first thing I thought. What are you doing? His attorney was doing fine. They had this big fight about spreadsheets. The attorney stated her position just beautifully, and then this guy thinks he's going to chime in. Oh no, with his little cuffs on. And then he even gave him one warning, and then it was it. That was it. It was over. Good times. And I even have some new stuff to clip. Thank y'all for coming out. I appreciate it. We never did find Karen accountant, but we did get to some spreadsheets and some contempt. So there you go. You never know. All right. Thanks a lot. I will see you all soon.